Welcome to the deep dive. Today we're tackling a really tricky area, economic torts. We're looking at that billion-dollar line the law draws between, just aggressive business and actual actionable malice.
That's right. And specifically, we're focused on claims for pure financial loss. So no physical injury, no property damage, just money lost because of someone else's wrongful act.
Exactly. And it's a tough balance, isn't it? The law wants to compensate people who've been ripped off, but it also doesn't want to stifle competition or, open the floodgates to lawsuits every time a deal goes south.
Absolutely. It's a real tension. You need to protect against intentional deception,
Yeah.
but you also have to avoid paralyzing markets with the fear of litigation.
Okay, so that's our challenge today. Our mission is to really get under the hood element by element. We'll break this down into three main parts. First, suing over a lie that's fraudulent misrepresentation or deceit. Second, suing when someone messes up your business relationship intentional interference, both with contracts and potential deals.
Got it.
And finally, that weird, rare beast, tortious breach of good faith, where a contract breach suddenly becomes a tort, usually involving insurance.
And the plan is to lay out the specific legal rules, the elements you need to prove for each. We'll use real cases and maybe some hypotheticals to see how these rules actually play out.
Right.
And then, crucially, we'll pull it all together at the end into a kind of diagnostic checklist for you so you can spot these issues and know how to start analyzing them.
Perfect. Let's jump right in with Module 1. Fraudulent misrepresentation, often just called deceit. This is the big one for lies causing purely financial harm. Punitive damages are often on the table here too, right? So what are the core elements we need?
Okay, for fraudulent misrepresentation, you need to hit 5 key points. 1, a material misrepresentation by the defendant.
Okay.
2, scienter.
Yeah.
This means the defendant knew the statement was false, or they were recklessly disregarding whether it was true or false.
Knew it or basically didn't care if it was true.
Got it. 3, an intent to induce reliance. They wanted you to act based on the lie.
Makes sense.
4, causation. The lie actually has to cause you to rely, and that reliance must be justifiable.
Justifiable reliance. We'll need to unpack that.
We will. And 5,
Yeah.
you suffered pecuniary damages, actual financial loss.
All right, 5 elements. Let's tackle the first one. Material misrepresentation. What counts as a misrepresentation of fact? Does it have to be a flat-out spoken lie? What if someone words something cleverly, but it's still misleading?
Yeah, that's a great question. It has to be about a past or present material fact. Material means, important to the transaction. So saying a painting is a genuine Picasso when it's a fake that's clear.
Right.
But it's broader than just bald-faced lies. A statement can be technically true, but still misleading. Like your example, if someone says company income has stabilized, maybe it has at 0.
Right.
If that creates a false impression of financial health, and that impression is material, that's a misrepresentation. It's about the net effect, the understanding it creates.
Okay, what about promises? Like if I say I'll pay you back next Tuesday, and then I don't. That feels like just a broken promise, breach of contract maybe? When does that become fraud?
It becomes fraud specifically, a fraudulent promise if, at the very moment you made the promise, you had no intention of keeping it.
Ah, okay, so it's about my state of mind when I said it.
Exactly. It's a misrepresentation of your present intent. If you fully intended to pay me back on Tuesday, but, I don't know, your circumstances changed unexpectedly, that's likely just breach of contract. But if you were lying from the start about your intention, that's fraud. The lie is about your current state of mind.
Interesting. But what if there are no words at all? Let's say someone's selling a house and they know there's this huge, ugly leak stain on the ceiling. So right before the open house, they slap a coat of paint over it to hide it. No lies spoken. How does that fit?
That fits perfectly. Misrepresentation doesn't have to be verbal. Actively concealing a material defect like painting over that leak is treated the same as lying about it. Yes, the act of concealment is the representation. It implies the surface is sound, that the hidden defect doesn't exist. You took active steps to create a false appearance. That counts.
Okay, that makes sense. Physical action as a statement. Now let's move to causation and that justifiable reliance element you mentioned. This feels crucial. What if the person being lied to is super smart, or maybe they even suspected something was up? Does the fraud claim fail then?
It can, yes. The misrepresentation must have actually caused the plaintiff to rely on it. It doesn't have to be the only reason they acted, but it needs to be a substantial factor.
Okay, substantial factor.
And if the victim wasn't actually deceived, maybe they knew the truth already, or they relied on their own investigation, not the lie, then the causation element fails.
This sounds like the Nader v. Allegheny Airlines case. Let's use our Fire Act structure here. First, what are the legally dispositive facts?
Okay, so Ralph Nader, the well-known consumer advocate, bought a ticket on Allegheny Airlines. He had a confirmed reservation but got bumped because the flight was overbooked. He sued, claiming the airline committed fraud by not disclosing its overbooking policy.
Right. He argued they implicitly represented he had a guaranteed seat. And what was the core legal issue?
The issue was whether the airline's failure to disclose the overbooking policy actually caused Nader to rely on having a guaranteed seat, especially given who he was, someone very familiar with consumer issues and airline practices.
What rule did the court apply to that issue?
They applied the fundamental rule of fraud. The misrepresentation, or non-disclosure in this case, must cause the plaintiff's reliance. If the plaintiff isn't actually deceived, there's no causation, and thus no actionable fraud.
Makes sense. And what was the court's analysis? How did they apply that rule to Nader?
Well, the court looked at Nader's history. They found evidence he'd actually been bumped from flights before and was generally aware that airlines overbooked flights, given his background and experience.
He likely wasn't truly deceived by the airline not explicitly mentioning the policy this time.
Exactly. The court reasoned he couldn't have justifiably relied on an implicit promise of a guaranteed seat because his own knowledge suggested otherwise. The non-disclosure didn't really cause his reliance because he likely knew about the risk anyway.
And the conclusion?
The conclusion was that Nader couldn't recover for fraudulent misrepresentation. The element of causation, the deception leading to reliance, was missing because of his prior knowledge. He wasn't fooled.
That really highlights the causation link. Now, back to justifiable reliance. You said reliance has to be justifiable, but this is an intentional tort. Does it matter if the victim was maybe a bit careless or naive? Like, should they have known better?
This is a really interesting point. While reliance must be justifiable, courts are generally quite protective of victims of intentional fraud. It's different from negligence. We don't typically allow contributory negligence as a defense to an intentional tort like fraud.
Meaning the defendant can't just say, well, you should have been smarter.
Pretty much. There's an old saying, even a fool deserves to be protected from intentional fraud. The focus is on the defendant's deliberate wrongdoing.
So the classic example, the person who buys the Brooklyn Bridge. If the seller intentionally defrauded them, the buyer might still recover, even if objectively it seems like a ridiculous thing to believe.
Often, yes. Courts hesitate to let a deliberate fraudster off the hook just because their victim was gullible. Now, there are limits. Reliance on something utterly preposterous or physically impossible might not be justifiable, but generally, if someone sets out to deceive you, the law doesn't place a heavy burden on you to be overly skeptical or conduct exhaustive due diligence, especially compared to, say, a negligence case.
Got it. Intentional wrongdoing shifts the balance. Okay, before we leave fraud, let's nail down damages. I hear there's a split in how courts calculate this.
There is, a major one. Two main approaches. The majority rule is the benefit of the bargain.
Benefit of the bargain. What does that mean in practice?
It tries to put the victim in the position they would have been in if the lie had actually been true. So let's say you buy land for $10,000. The seller fraudulently tells you it's worth $15,000 based on some fake appraisal. In reality, it's only worth $3,000.
Okay.
Under benefit of the bargain, your damages are the value as represented, $15,000, minus the actual value, $3,000. So you'd get $12,000. It gives you the profit you expected based on the lie.
Wow, okay. So more than just getting your money back, what's the other approach?
The minority approach uses the out-of-pocket rule. This is the more traditional tort measure. It aims to restore you to the position you were in before the fraud occurred.
How does that work with the same land example?
In that case, it's the amount you paid, $10,000, minus the actual value you received, $3,000. So your damages would be $7,000. It just covers your direct losses.
Big difference, $12,000 versus $7,000.
Huge difference. And remember, on top of either of these measures, if you can prove the defendant acted with malice, which is often inherent in proving scienter for fraud, you can potentially get punitive damages too.
Which could dwarf the actual economic loss. Okay, that's a solid foundation for fraud. Let's shift gears now to our second big area, intentional interference with economic relations. We're moving from lies to messing up someone else's deals.
Exactly. Protecting relationships. There are two main torts here, very closely related. Interference with an existing contract and interference with prospective economic relations, like a potential deal or customer relationship that isn't yet locked down by contract.
And they have similar elements, but maybe different standards?
Precisely. The core elements are parallel, but the level of protection the law gives, and critically, the justifications a defendant can raise, differ significantly between interfering with a solid contract versus interfering with just a potential future deal.
Okay, so what are those parallel elements for both interference torts? Let's get the list.
Sure, you need 1, a valid contract for the first tort, or a valid economic expectancy for the second tort, between the plaintiff and some third party.
Got it. Contract or expectancy.
2, the defendant has to have knowledge of that contract or expectancy.
They got to know about it.
3, the defendant must have the intent to interfere with it.
Okay.
4, the defendant's actions must actually cause the interference or breach.
Makes sense.
And 5, the plaintiff suffers damages as a result.
All right. Seems straightforward enough. Let's talk about interference with contract first. The classic case here is ancient, right? Lumley v. Guy, some opera singer.
Yes, 19th century. Basically, an opera singer, Johanna Wagner, had an exclusive contract to sing at Lumley's theater. Guy, who ran a rival theater, knew about this contract but persuaded Wagner to breach it and sing for him instead by offering her more money.
So who got sued, and what's the takeaway?
Lumley sued both Wagner for breach of contract and Guy for inducing the breach. The big takeaway from the case against Guy was establishing the tort of intentional interference with contract. It showed that a third party who intentionally causes someone to break their contract can be held liable in tort.
Even if they were just competing, offering a better deal.
Yes. For an existing binding contract, simply offering more money isn't usually a valid justification for inducing a breach. Guy was liable for Lumley's losses, potentially including things beyond just contract damages, like maybe even punitive damages if malice was shown.
Okay, so messing with existing contracts is risky. Now that knowledge element seems key. How much does the defendant need to know? This came up big time in that huge Texaco v. Pennzoil case, right? Billions were at stake there. Let's run the fire rack. What are the facts?
Right. This was massive. Pennzoil had negotiated a deal to acquire a large block of Getty Oil stock. They had reached what they argued was a binding agreement, though some documents were still unsigned, basically, an agreement in principle. Texaco then swooped in, knowing about the Pennzoil negotiations, offered Getty shareholders a higher price, and bought the shares instead.
Okay, so Pennzoil had a deal, maybe not fully signed. Texaco knew something was going on and jumped in. What was the core legal issue?
The central issue was whether Texaco had sufficient knowledge of Pennzoil's agreement with Getty to be liable for interference. Did Texaco need absolute proof of a signed, sealed contract, or was knowing the essential terms and the fact that an agreement in principle had been reached enough?
Crucial question. What rule did the court apply regarding knowledge?
The court applied the rule that the defendant doesn't need certainty. They need knowledge of facts, which, under the circumstances, would lead a reasonable person to conclude that a contract existed or that a binding agreement was highly probable. Basically, you can't just stick your head in the sand if all signs point to a deal existing.
Okay, so constructive knowledge counts. How did the court perform its analysis using that rule?
The analysis focused on what Texaco knew or should have known. There were press releases, board resolutions, the nature of the negotiations. The court and jury concluded that, based on all the information available to Texaco's sophisticated dealmakers, they should have realized that Pennzoil and Getty likely had a binding agreement under New York law, even if not every I was dotted and crossed on the final papers.
They couldn't claim ignorance given the context and the conclusion.
The conclusion was that Texaco did have sufficient knowledge and did tortiously interfere with Pennzoil's contract. The jury awarded Pennzoil billions in damages. It sent a huge message. Willful blindness about an existing contract won't protect you if the facts should have put you on notice.
Wow. Okay, knowledge is key. Now, let's contrast this with interfering with prospective relations deals that aren't finalized. You mentioned justification is more relevant here. How does fair competition work as a defense?
Right. This is where the difference really shows up. For interfering with an existing non-terminable contract, like in Lumley or Texaco, the justifications are very narrow. But for prospective relations trying to win over a customer who isn't locked into a contract, or competing for a deal that's still being negotiated, the law gives much more leeway.
So competition is generally okay there.
Yes, fair competition is a recognized privilege, a justification for interfering with prospective relations. The whole point of a market economy is to compete for business that isn't already contractually obligated elsewhere.
Okay, give me an example contrast.
Sure. Let's say you and I both run competing hamburger stands. If I stand outside your stand and just tell potential customers, hey, my burgers are way better and cheaper, come over here, that's probably fair competition aimed at your prospective customers. Annoying for you, but likely privileged.
Okay. Annoying but legal.
But if instead I stand there and yell, don't eat his burgers, he put spider eggs in them, assuming that's false, of course,
Let's hope.
then I'm using wrongful means. I'm committing an independent tort, defamation, to steal your customers. That interference is not privileged. It's not fair competition. It's tortious interference because the means used were improper or unlawful.
Got it. The method of competition matters hugely when it's just an expectancy. Okay, that clarifies the interference torts. Let's move to our third and final and maybe most specialized category, tortious breach of the covenant of good faith and fair dealing.
Right, the oddball.
Every contract includes this implied promise to act in good faith, right? But usually if you breach it, the damages are just standard contract damages, expectation, maybe reliance. So why and when does this breach suddenly explode into a tort claim with potentially massive tort damages?
It's a very narrow exception, usually called a bad faith tort. It happens when the breach is considered so egregious, such a violation of fundamental fairness in a specific type of relationship, that the law treats it as a serious private wrong deserving of tort remedies.
Like punitive damages and emotional distress.
Exactly. Things you almost never get in a standard contract breach case.
Okay, so what's the underlying policy? Why single out certain breaches for this special, harsher treatment?
The overwhelming justification and where this tort is almost exclusively applied is in the insurance context. Think about it. When you file an insurance claim, say after a fire, you're incredibly vulnerable. The insurance company holds all the cards, the money, the expertise.
Sure.
If the only penalty for an insurer intentionally denying or delaying a perfectly valid claim was eventually having to pay the original claim amount, contract damages, they'd have a strong incentive to stonewall claimants, right? Wear them down, force them to settle cheap.
Yeah, the worst case is they pay what they owed anyway, just later.
Precisely. So the threat of tort damages huge punitive damages, damages for emotional distress caused by their bad faith conduct, is seen as necessary to level the playing field and deter insurers from abusing their power. It forces them to handle claims in good faith.
So it's really about that power imbalance and vulnerability in the insurance relationship. Now, I know California experimented with expanding this beyond insurance for a while with a case called Siemens. What happened with that? Where do courts generally stand now?
Yeah, Siemens was a big deal for a while. It suggested that maybe any bad faith denial of the existence of a commercial contract could potentially trigger this tort liability.
That sounds broad.
It was. And it caused a lot of concern. Critics worried it would completely undermine the predictability of contract law, turning every disputed contract into a potential high-stakes tort case.
So what happened?
Eventually, the California Supreme Court pulled back. In later cases, like Freeman and Mills and Foley, they effectively overruled Siemens and strongly reaffirmed that the tortious breach of good faith claim is, with very few niche exceptions, generally confined to the insurance context due to that special relationship rationale we discussed.
So the expansion failed, and it's mostly back to just insurance companies facing this specific tort.
That's the modern majority rule, yes. Unless you're dealing with an insurer denying a claim in bad faith, you're almost certainly looking at standard contract remedies, not this special tort.
Okay, that's a critical limitation. We've covered a lot of ground fraud, interference, bad faith breach. For someone facing an exam or analyzing a real-world problem involving economic loss, how do they pull all this together? Can you synthesize this into that actionable diagnostic checklist you promised?
Absolutely. Here's a way to think through it step by step when you see purely financial harm. Step 1, initial check. First, ask, is the loss purely economic? Meaning, no related physical injury to a person or damage to other property.
Yeah.
If yes, then you know you're potentially in the realm of these intentional economic torts.
Okay, filter for pure economic loss first.
Step 2, deception or disruption. Next, figure out the mechanism of the harm. Was the loss primarily caused by a lie, a false statement or concealment, or was it caused by someone breaking up a business relationship?
Lie versus broken relationship.
If it's a lie, false statement, your primary tool is the fraudulent misrepresentation checklist. Go through the elements. Was there a material misrepresentation of fact? Did the defendant have scienter knowledge or recklessness? Intent to induce reliance? Did the lie cause justifiable reliance? Were there pecuniary damages? Pay special attention to that justifiable reliance. Remember the fool's rule, intent matters.
Okay, fraud checklist for lies. What if it's relationship disruption?
If it's relationship disruption, you use the intentional interference checklist. First, identify. Was it interference with a valid contract or just a prospective economic expectancy? Then, check the other elements. Defendant's knowledge, intent to interfere, causation, damages. Critically, if it's only interference with a prospective expectancy, you must rigorously analyze the justification defense. Was the defendant's conduct privileged as fair competition, or did they use wrongful means, like defamation, threats, or violating the law? That distinction is key.
Got it. Check justification carefully for expectancies. What's the last step?
Step 3. The insurance exception. Finally, if the facts involve what looks like a breach of contract, but the plaintiff is seeking massive punitive damages or emotional distress damages, ask, is this the special insurer-insured relationship? If not, the claim for tortious breach of good faith and fair dealing is highly unlikely to succeed outside of insurance. That tort is generally reserved for that specific context.
Perfect. That framework, economic loss, lie or disruption, check justification, insurance exception, really clarifies the analysis. This whole deep dive really highlights that complex line drawing, doesn't it? Between just, hard-nosed business competition, which the law protects, and intentional deception or disruption, which it punishes, often severely.
It absolutely does. And that line isn't static. It's constantly being debated and refined by courts and scholars, which leads to maybe a final thought for you to chew on.
Okay, leave us with something provocative.
Consider the ongoing debate about how to handle the justification element in intentional interference, especially with prospective relations. The older approach, from the restatement, second of torts, used a flexible, multi-factor balancing test to decide if interference was improper. It looked at motives, interests, social utility, very fuzzy.
Sounds unpredictable.
It can be. The newer restatement, third, pushes for a much stricter approach. It basically says interference with prospective relations isn't tortious unless the defendant's conduct is independently wrongful, like committing another tort, defamation, fraud, or violating a statute.
So clear rules over flexible standards.
Right. The debate is really about what best serves a dynamic market economy. Do we want judges making case-by-case ethical judgments using fuzzy factors, or do we want clearer, more predictable rules, even if that sometimes protects conduct that feels sharp or maybe unethical, as long as it's not independently illegal? Which approach ultimately leads to more efficient and predictable business dealings? Something to think about.